Hello everyone and welcome back to Exam Ignite YouTube channel. This is the module 3 part 2 video of the RMI subject of the 5th semester. So let's start with the process of patenting. Here the first topic comes the prior art of search and choice of application to be filled and patent application forms, jurisdiction of filling the patent application, publication, pre-grant opposition, examination, grant of patent, then validity of patent protection, post-grant opposition, commercialization of a patent, need for the patent agent, can a worldwide patent be obtained, do I need to file first in India, patent related forums, fee structure, types of patent application, commonly used terms in the patent, national bodies that is dealing with the patent affairs, and the utility models. So let's get started. This is one of the important and expected question in the exam, that is step-by-step process for obtaining a patent for initial idea to the grant of patent. So it includes major 3 steps: prior art of search, choice of application to be filled, and pre-grant opposition. They may ask you like that also to explain. So let's get started. It is a systematic legal procedure that is governed by the Patent Act 1970. It starts from an initial idea or an invention and ends up with a grant of patent after the examination and the opposition stages. So this procedure ensures that only the invention satisfies the statutory requirement are granted protection. So filing an application with the IPO, that is in that web portal, then publishing, then examining, then grant for the patent. So this is a flow chart of the major steps involved in the grant of patent. Now let's move on. Idea or invention. This is the process where it begins. It is developed by the inventor and must be capable of satisfying the novelty, invention step, and the industrial applicability, as we have discussed earlier. Next, it comes the prior art of search. This is conducted to determine whether the invention is already known. Like search is carried out in the existing patents, in the journals, in the research articles, in the published literature. This step helps to assess the novelty and inventive step and chances of patent grant. Choice of patent application. Here, the inventor should decide the type of application that is to be filled. Like stage of development, it depends on the stage of development of invention, availability of the complete details. This step is crucial for ensuring the proper legal protection. Filing a patent application. It is filled in the appropriate patent office or in the portal. This includes application form, specifications, and required fees to be paid. Filing establishes a priority date of the invention. Publication of the patent application. After filing, it is published by a patent office. So the publication makes the invention available to the public. From this stage, the provisional rights for the applicant comes into effect. Pre-grant opposition. So as soon as any person files a opposition, it is opposition is filed before the grant of the patent. So it is raised on the grounds specified under the Act of Patents. So this step ensures the undeserving inventions are not granted patents. Then request for the examination. So the applicant must file a request for the examination. So without the request, the application will not be examined. So the examination begins only after you submit the request for examining. Then examination of that application. As they receive that letter, they will start the compliance with the legal provisions and patentable criteria they will check, and any examination report is issued. Next comes objections and reply. So during preparing the examination report, they may contain any objections. So this applicant must respond to that objections and amend the claims if required. Failure to respond, then it will be rejected. Finally, grant of patent. If all the objections are solved and required are satisfied, the patent is granted. The granted patent is entered into the register of patents and the applicant becomes the patentee with the exclusive rights. So you can draw the flow diagram like this: idea or invention, prior art of search, then comes choice of the application, filing the application, then publication, pre-grant opposition, request for the examination, examination and objections, then comes the grant of patent. So these are all the steps that is involved in the complete process. Then comes what strategies are involved in the commercialization of a patent. So this is asked in the model question paper 2 and June-July 2024 paper. This refers to permitting others to make use or sell a patented invention. The owner grants permission based on the mutually agreed terms and conditions. What are the strategies involved? Firstly, licensing of patent means the owner may grant a license to an individual, organization, or industry that allows to make, sell, or use the patented invention. The reasons for granting a license is owner has a decent job. Example, if he is a university professor and does not wish to exploit the patent personally. Second thing, a patent owner lacks the manufacturing facilities. Like you cannot fully use that. Manufacturing facility is unable to meet the market demand. Then the patent owner wants to focus on the geographic market and license rights for other regions. Then rights of the patentee. Once the patent is granted, patentee enjoys the exclusive rights over the invention. Only the patentee has a right to license or deal with that patent. Then the validity is around 20 years from the date of filing. Working or licensing of patent. So this must submit the form 27 every year and provide information about the commercialization or selling. They have to show that patent is where it is sold or where it is commercialized. This requirement is known as the working or licensing of patent. What are the types of patent licensing? Exclusive license means it is licensed to only one individual or organization and it is granted for only fixed time period and no other entity can exploit it. Non-exclusive license means it a patentee may license the patent to multiple parties. Multiple individuals or organizations can exploit the patent simultaneously. Compulsory licensing. The compulsory license provision, if the patent failed to commercialize the patent within the 3 years from the grant date, compulsory licensing may be applied. Any person can apply to this controllers of patent for compulsory licensing. What are the conditions here is reasonable requirement of public are not satisfied, invention is not available at a reasonable price, the invention is not working or not worked in the territory of India. Then why do we need a patent agent? So it is a application can in general an applicant can prepare and file the patent application without assistance. The patent documents are complex, hence it is advisable to seek help from an agent. So what he do, he helps in drafting the application correctly. Many countries require that an applicant whose ordinary residence or the principal place of business is outside the country must be represented by a qualified patent agent. So this should decide the practice in country where the patent is filed. Can a worldwide patent be obtained? No such terms as universal patent, world patent, or international patent. There is nothing like that. Patent rights are territorial in nature. That is, it must be filled with patent office of each country where the protection is required. Filing it separately in many countries, it is time consuming or you can say it is expensive, it is waste. Next is regional patent offices. To reduce the complexity, regional patent offices have been established. They include European Patent Office, African Regional Intellectual Property Organization. A single application can cover multiple countries that are the members of this regional office. Next is Patent Corporate Treaty, PCT. In many countries worldwide, filing under this PCT is referred because the condition of this application is that applicant's country must be the PCT member. India is also PCT member along with over 190 nations. In which circumstance Indian residents are not required to file a patent application first in India to get the patent protection in another country? Or do I need to file a first? Do I need to first file a patent in India? So this was asked in model question paper 1. Coming to the answer, first requirement in India, Indian residents are required to file a patent application in India. After filing in India, they may seek the patent protection in other countries. For filing outside India, for filing outside India, prior approval from the Indian Patent Office is required. Circumstances where first filing in India is not required. So if applicant is not an Indian resident, not required, expiry of 6 weeks after the filing in India, then invention developed abroad with Indian resident has co-inventor, international collaborations, inventions related to restricted domains, these are not required. Next, patent related forms. So there are 30 patent related forms. So form number 1 is grant of application for the grant of patent. 2 is complete specifications. Like this, we are having 30 patent related forms. Next is fee structure and the types of patent application. Fee structure based on the category of applicant, like natural person or the startup, small entity or others like that. It is done if you fill it electronically, that is 10% cheaper than physically filling. So you need to know this table. Here for a natural person, we are having items like complete specification, request for the early publication, request for the examination, request for the express request for the examination. So for the startups, it is this amount. For a small entity, this is the amount, or others alone with the natural startups or small entity, this is the amount. Renewal fees is also given 3 to 6 years, 6 to 10 years, 11 to 15 years, 16 to 20 years. Types. First is provisional application. The field when the invention is not fully finalized, some part of the invention is still under the experimentation, helps in obtaining the priority date. So this is called provisional application. Ordinary application means it is filed with the complete specifications and claims and does not claim any priority date. PCT application, that is Patent Corporation Treaty, it is filed under that. A single application allows filling all the PCT member countries, so helps in claiming the priority internationally. Divisional application, this is for more than one invention by a single applicant and filed voluntary or due to the official objection. So this date is same as the patent application. Patent of additional application. This is filed when the invention is slightly modification of the existing patent invention. This modification must be a new one. No separate renewal fees is required for this. Next is conventional application. Filed when same invention is to be filled in conventional countries. So same claims the claims the same priority date in the Indian application. This must be filed within the 12 months from the date of filing in India. What are the commonly used terms in the field of patenting and how do they contribute to the effective communication in this domain? So this was asked in the December-Jan 2024 paper. Some terms like inventor, applicant, patentee, licensee, assignee, enforce, working of a patent, patent specification, priority date. So these are some of the terms. So the role of this in effective communication is they provide a standardized vocabulary, they avoid misunderstandings, they provide a clear legal and technical and commercial communication. So these are all the effectiveness. National bodies dealing with the patent affairs. So here there are many departments. One is Indian Patent Office, Department for Promotion for Industry and International Trade, Technology Information Forecasting and Assessment Council, National Research Development Corporation. Next, the last question, what are utility models and how do they differ from the patents? This is model question paper 2 question. In many cases, an invention involves an incremental improvement over the existing product. Such improvements may not be satisfy the stringent criteria of patents. So definition of this is legal protections given to small innovations like petty patents, innovation patents. So these protect the inventions where the criteria of novelty and the non-obviousness or the delayant or you can say that is provided into the research. So criteria for the utility models is a requirement for the industrial application or utility same as the patents. It is criteria of novelty, non-obviousness, or the less stringent compared to patents. Utility models and MSMEs. MSMEs are the micro, small, medium enterprises. They are helpful for that, and they grant the utility model is less rigorous, involves a minimum cost, and they often lack the resources for intensive R&D required for patents. So their innovations improve products or process and bring the financial rewards. Life of utility models is less than the patents, around 7 to 15 years. It is countries recognizing utility models are only 80 countries, and some of them are given here. Then in India, India does not recognize this utility models under the IPR. The recognition of utility models in India would increase the number of patents filed and granted annually. So the difference is the level of innovation. In the utility model, the incremental improvement; in the patent, it is significant technical advancement. In novelty, it is diluted or relaxed. In the patent, it is strictly required. Grant process, utility model, it is less rigorous. In patent, it is highly stringent. Duration is 7 to 15 years. Here it is 20 years. Thus, you can say utility model provide a cost-effective protection for the small innovations with relaxed patentable criteria, making them suitable for MSME. While the patents, they are for the high standards of innovation and novelty. So this was all about the module 3, and this comes to the end. And thank you for watching. Please do like, share, and subscribe to Exam Ignite YouTube channel for these type of contents. And thank you. See you in the next video.